Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Excuse me. 100 years ago, a person was alive when born and died when the heart stopped beating. Recent medical and technological advances have changed how Americans view being alive or dead. Recent decades have been filled with decisions, litigation, and arguments about these very personal subjects. The cases of Karen Quinlan, Nancy Cruzan, and Terry Schiavo, all of these people had been reduced to a vegetative state, are examples of arguments about the end of life. More recently, there have been discussions and lawsuits filed about the custody of human embryos created by in vitro fertilization, manually combining an egg and sperm in a laboratory dish and then freezing the embryos for future implementation. The legal argument is between a couple who agreed to create the embryos but now disagree about whether the embryos should be brought to term, or left in the freezer, donated to others, or destroyed. My guest today is Jasha McQueen. She's a litigant in just such a lawsuit. She and her ex-husband are struggling through the courts seeking a decision about what is to be done with their two frozen embryos. Today's discussion is at the cutting edge of medical capability and legal process. Jasha McQueen, welcome to Conversation.
Thank you for having me, Lee.
So, just so that we get right started, you're an attorney.
Yes, I am.
Okay, so you know, at least you thought you knew what the law was.
Right, I thought I did.
But things have not gone as planned. So I'm going to let you describe from the very beginning of, here you were married, here you were planning on having children.
Yes.
And decided to have this in vitro process in which 4 embryos were created.
Sure.
So starting from there, and perhaps tell people why you even did that in the first place.
Okay, so me and my husband were geographically separated. So
he was in the military.
He was in the military.
You had been in the military.
I was
too.
I was in the Army previously as well. But
at that time.
At the time, I was an attorney, and my practice was in St. Louis. And he was actually over on the East Coast of the United States, and then he ended up getting deployed. Well, before he got deployed, we got married, and we decided to freeze his sperm, and just in case. And plus, I was getting older, and we wanted children, and so we decided to go ahead and freeze his sperm before he left. I believe he went to Iraq. And went to Iraq, and then he told me, well, you can go ahead and try, while I'm in Iraq. Well, come to find out, when they defrosted the sperm, or thawed the sperm, that his sperm didn't survive the freezing process. And so it would have been near impossible for me to have gotten pregnant off of his sperm. So when he got back, we talked, we were still...
Well, that would have been injection, not in vitro fertilization.
That would have been what they call the turkey baster method.
Right.
Okay, you can use your imagination on what that means. So that wasn't going to work. And so what ended up happening was once he got back from Iraq, he was still on the East Coast of the United States, and still geographically separated. We didn't know how long we were going to be separated or how long he was going to stay in. And so what we decided to do was to go ahead and do IVF, in vitro fertilization. And the reason we did that was because the doctor had told me that because I didn't have fertility issues, that they did not want to do any other type of, what is it called, reproductive techniques. Because if they did, I would probably end up with multiple children, like 8 or something like that, crazy.
Yeah, like that one woman who had a whole host of
that
children.
Octomom, right?
Yeah.
I would have been like Octomom. So they said that's incredibly dangerous, and so they said what's better and more controlled is if we did IVF. So we went through that process to get that done.
And you and he were in the same place at that time, or was he still
He was still away, and I was still here. And so what happened was we did a lot of paperwork. He would come in and visit. We'd go to the doctor. We would do all that. And then
so that was done in St. Louis.
It was done in St. Louis, exactly.
So that's why this is a Missouri case?
Yes, it's a Missouri case because we signed the contract in Missouri as well.
Okay.
And so even though the actual cryobank is in Pennsylvania, it's a Missouri contract because we signed it here. So, so basically what happened was we ended up creating 4 embryos, okay? And
was that the intention for, or that's just what happened?
That is what happened. We knew we didn't want a lot, okay? So it used to be back in the day when they were doing this that they would create like crazy amounts of embryos, right? Some people, you'll read in some of the cases like 17 or 20 or whatever. But he knew that some of them have a more ethical practice, some of the doctors, and my doctor did. He wanted to make sure we had just enough, a reasonable amount. And I think they're doing that now. I mean, now you'll find that that's what the doctors are doing. They're not creating all of these like they used to. So we created 4. I think we started off with like 10 or something, and it whittled down to 4 that were actually viable or alive and able to develop. And the other ones obviously died and didn't make it. So out of the 4, we took 2, and he asked me, do I mind having twins? I said, no, I don't mind having twins. But he didn't want to implant the 4 because, again, I would end up probably getting pregnant with the 4, and that would be dangerous. So he said, let's do 2, and then you can keep 2
so this
for later.
Almost contemporaneous with the creation of the embryos.
Yes, it did. So they took 2 of the fresh ones, and they implanted them. And the other 2, which are the full-blooded siblings of my current 2 twin boys, they ended up going in a frozen state, in cryo-freeze. And so at the time when we did the cryo-freeze, we had an agreement. And in that agreement, they again stated there were certain exceptions. All of these agreements basically say that one person could not use the embryos without the other person's consent. Okay, so that's like a basic agreement. And then in that agreement, some of them, not all of them, but some of them, mine did, has exceptions to that. So they would say, okay, in case of death of one of the parties, what would happen? In case of separation or divorce, what would happen? In case both people died, what would happen? So those are kind of contingencies in those agreements. And mine had those 3. And at the time, we had agreed that I would get the embryos upon divorce, okay? We initialed, signed everything. Now, I don't have a copy of that agreement, unfortunately, but I'll get into that. So that was in 2007.
Now, pause there for just a second. Go ahead. That, which you just said, is under legal contention, right? That he agreed that if there was a divorce, that you would get custody of the embryos.
Yes, that is what is under legal contention.
Okay.
Now there was never any. Now this is the first agreement I'm talking about, which we did discuss at the trial level. He said he didn't remember signing it. I went into detail, said yeah, he did sign it, which he did. And so that's the first agreement. But the first agreement was never introduced as an exhibit because we couldn't find a copy of it. Okay. So that was the first time. So that's in 2007. Anytime you freeze embryos, you have to have a storage agreement. Okay. It's just like any other storage that you go to. You have to have an agreement for it, for them to know what to do in certain cases and contingencies. So we signed the agreement. Then we went.
So this is a whole separate contract.
That's a whole separate
from the one you were just describing.
Right. Okay. The current one that's at issue, because that's the most current one that we did. So that one, we went ahead and signed everything. We got that done. We ended up having 2 beautiful twin boys. They're 7 years old right now. And then we had plans to use the other 2. So we didn't do it right away. Obviously, most couples wait for a couple years before they do that. Our relationship ran into some issues, okay, like a lot of relationships. The one thing that ended up happening is that, well, in 2010, let me just go chronologically. So in 2010, my doctor was retiring, and so we had to redo the agreement with a new cryobank because he wasn't able to store them any longer. So he recommended the cryobank out in Pennsylvania because he said that was a really good bank and they could, survivability rate was great and et cetera, et cetera. Okay. And so they sent us an agreement. And in that agreement, this is the contested agreement, there are those 3 contingencies that we talked about. And we signed them, we initialed them, we went along our merry way with our days. And then in the fall of 2010, my ex had an issue. He ended up hitting me and giving me bruises around my arms and bloody nose in front of our 2 boys. And so that night is when I left. And I had a restraining order against him, and all of this is public knowledge, And so then ensued the divorce, which became very ugly and very, very difficult, as you can probably imagine. Mm-hmm. And my big thing was I was trying to make sure my boys were safe because I knew he had a history of alcohol issues. And, and I knew him better than anybody else knew him. So we went through the divorce system. And finally, once everything was concluded with my 2 boys, well, during this time, it's been it was like 4 years when we finally got to trial on the embryo issue. Everything else had been settled out, custody of my boys, all that. And then we went finally to the embryo issue, which was September of last year. We went to trial on it.
So your children at that time were 7 or 6, 5, 6?
Last year?
5,
mm-hmm.
6, something like that?
Yeah.
Okay, so now you come now you come to trial. You've got your document.
I do, yes.
Did he have his document, or it was just the one that went in front of the court? Was that yours? Both of yours? Was that your paper? Was his paper?
We had our trial was a little bit odd in that there were some documents that weren't exchanged ahead of time, et cetera. But we went through. We had our copy, and then they had their copy of the document. And so they introduced that, and we introduced ours. It's basically the same copy. Mm-hmm. And that's how the trial went. He basically, what happened was he basically told me, once we split, okay, that was fall of 2010, he actually wasn't even thinking about the embryos. And then I think several months later, this came up, and he said, well, I don't want the embryos, I want to terminate them. I don't want anything to do with them. And I said, well, that's not what we agreed to, And he said, well, I don't want anything to do with them now. And so it turned out that I didn't have any idea about the case law at the time. I wasn't an embryo attorney, or I wasn't trying to look in the very, very small amount of cases. We're talking about 12 cases, nationwide that has gone to the appellate level or above. And there have been none that have gone to the federal or Supreme Court at this point. So you're talking about a small number of cases. And so when my attorney gave me the cases, they were, maybe 12 or so, maybe less. And I ended up reading these cases. And the more I read, the more perplexing it was for me, the more confused I got. Because I'm an attorney, my whole basis is that I believe in the system, and I believe the system works, and so to have this kind of thrown in your face, to see where something is so one-sided that there's nothing you can do to protect your rights.
Well,
it makes it a little bit.
Let's pause there and describe to people what it is that you're thinking, because you're thinking something, but you haven't described to people mm-hmm. what it is that you found so confusing about these cases. So what were some of the issues that you found
The bottom
confusing?
line with these cases are that in cases where it was to terminate the embryos, okay, where 2 parties decided or had decided to terminate, the courts upheld the agreements. But in cases where it was to give it to one of the parties, the court found every excuse not to uphold the agreement. That's the part that I felt that was very unjust, because it's almost like, well, there's nothing you can do if you want to save your unborn children. There's nothing you can do about it. You can't have an agreement, because the agreement won't be upheld no matter what you do, only if it's to terminate. So that type of idea to me was very disturbing, because in my mind, as an attorney, I'm like, a contract's a contract, an agreement's an agreement. You know, that's what we enforce in the courts.
But you found that a contract's not a contract in this case.
Right. That's
Is
what they
that
said.
what the trial court, your trial court, determined? That a contract was not a contract?
Yes, they determined. Now first of all, what they did was they tried to invalidate. Well, they invalidated the contract. They said that he didn't know what he was doing. That, you know, that I as a person might have filled in using my name to get the embryos, maybe after he had already initialed or signed it. Again, these are all suppositions that actually was not brought up by my ex in trial, because he didn't even remember, and he even said it, and he said he signed it, he said he initialed it, he said yes I did, and when he was asked if he read it, he said, well, no. And when he was asked,
he was counting on you, the attorney, to say where to sign.
Right, that's what he said, and my attorney, he said, you know, well, you can read, right? And he said yes. And she's like, so you chose not to read these? And he said, yes, I chose not to read them. So with all of that, you know, first of all, we did talk about it. I mean, I know we did. The judge decided to take his version of it, which is her right as a commissioner to do. You know, she's weighing the credibility of the evidence, I get it. But the mental gymnastics they went through to invalidate the agreement doesn't hold water in a normal setting.
No, they want to. It's said that these kind of cases are first impressions. Is that the proper term?
That's right.
And that in a first impression case, it's up to the court to decide what the law is. Isn't that right?
That's right.
And therefore, the rules that might apply to a regular custody case of a 1-year-old or a 2-month-old don't necessarily apply in this case.
If the court determines that, which
that
is what the court.
Impression.
Well, that's what the court determined. Now, I have a lot of issues with the judgment, just because, I mean, I know how law is supposed to work. You know, we were taught from the very beginning when you're in law school how you evaluate the law. You know, and the first thing you do is go to the statutes. That's the very first thing you do. She didn't do that. She didn't go to the statutes. She went to a few statutes, selective ones, but she didn't address the other statutes.
She being the judge?
The judge, the commissioner. She's a commissioner.
Oh, she's a commissioner.
Right.
What's the difference?
Well, Missouri has this weird commissioning system. I'm not even quite sure how it works, but she's not a judge, so she needs a judge to actually approve her judgment. You know, so she's
kind of like a paralegal or something. You're working under a
well,
license.
She's an attorney. She's an attorney, but she doesn't have I guess the
judge's commission.
Yeah, she's just a commissioner, so kind of like a judge in training, maybe. I'm not quite sure how it works. It's a family law thing, so, and I'm not a family lawyer, so. But what she did was she jumped right into another state's court cases.
The Iowa case.
Right. As opposed to looking at the statutes and evaluating how Missouri would handle it. See, that's what Iowa did. If you read Iowa's case law, they went first to the statutes. They say, you know, how is this viewed by Missouri? You know, what kind of, how should these laws be constructed? You know, they looked at that before they jumped into it. And the commissioner here, she just said, well, I like Iowa. And, you know, it's basically, there's no citations, there's nothing in her case, in her judgment.
Let's pause there. Iowa's decision, was that an appellate decision?
I believe the Supreme Court.
Okay, so the Iowa Supreme Court decided that a deal's not a deal at the moment of signing papers, but the deal is a deal at the time when the decision comes to implant the embryos. Isn't that right?
Oh, right.
So, and the Iowa case also says that while someone may have wanted to have children at one moment, they may change their mind later on. And in Iowa, apparently, it is now permissible for people to change their mind right up to that moment when the embryo is implanted, right?
Right. That's how they viewed it.
Okay.
Which to me is and that's part of, well, it's kind of a hybrid balancing test kind of how you describe it, because what they do is if they don't enforce it, then they look at the rights of both parties and they balance those rights. Okay, so there was a couple of really actually famous cases, one over in Illinois just recently with Carla Dunstan. She was trying to obtain her embryos. I think she had 3, and she was going through cancer treatments. They had signed an agreement, and she ended up actually getting custody of her embryos, and the reason is because she had cancer. And so this was her only avenue of producing children. So they did that balancing test in that circumstance. The one over in California with Mimi Lee and Findley, Mimi is trying to obviously get her embryos as well. She actually signed an agreement that said that upon divorce they would be thawed out and destroyed. So hers is a lot more difficult, for her. But again, if you use the balancing test, then you just throw the agreement to the side and the courts are deciding who gets the embryos and who doesn't. That's my biggest problem with this, is that the courts are deciding such a private decision to be made. They're making it for people now.
Now,
and that to me is disturbing.
Where's your case stand right now?
We filed the notice of appeal June 25th, and so we're now just going through the process, determining what's on the record, what they're going to be, what the appellate court's going to be
Missouri
reviewing.
courts or U.S. district?
No, Missouri courts.
Missouri courts.
Yeah, it's in the eastern.
For the Eastern District. And how long of a process is this?
I'm not sure. It can take...
Normally, I mean, if you were to file in the Eastern District...
1 or 2 years.
Okay.
Yeah, 1 or 2 years probably.
People, you just say, 1 or 2 years. now, Miss Lawyer, now you get to see what it's like being on the other side when you're a litigant, and now they say, well, you don't get a decision for another year or 2. And then after that, God knows, it could wind up going to the Supreme Court.
It could.
Of Missouri, right?
It could, yes.
Right.
Yeah, that would be our second bite of the apple.
Because the legislature has no law.
They have no law, and let me tell you, I am moving towards that, trying to get some law in place and trying to draft up some legislation.
But it won't be
to get that
retroactive
done.
to your case.
Well, I mean, if it ends up getting sent back to the trial level, it might very well be. What happens is, because I believe we will have probably a second bite at this. Let's say if we go to the Court of Appeals, and because the judgment has so many holes in it legally, I hope
So they just throw it back?
They'll throw it back, yeah. And then at that point...
And then it's like that first trial never took place.
Exactly. Now that may happen, it may not.
But you better put a stronger case together.
It may not, it may not happen. Well, this is the thing. The strength of the case really doesn't make any difference, because what we have all this case law that's all over the place, and that's done by, and they're all states are different. This is the thing, this is what makes our country beautiful in a lot of ways. We are supposed to have a republic still, whether we do or not, I don't know, or whether we keep that remains to be seen. But currently, every state is different. Every state has their laws. For example, in Missouri, there is a construction of statutes, what they call preamble, and it's Missouri 1.205.1, and it states that life begins at conception.
This is Missouri?
This is Missouri, okay? Life begins at conception. It says that all
What is an embryo then? What is the difference between embryo and fetus?
It's the embryonic stage. It's the stage before it turns into a fetus. See, there's a lot of different stages. And so that's just a scientific term that's been used for that particular stage. And it's between, probably in the first trimester is probably what is more like the embryonic stage. But there's a point where it becomes a fetus. Scientifically, I'm not sure, but I do know that when you have a sperm and an egg and they're fertilized, that's when life begins.
That's Missouri's law.
Missouri's law says,
it's when the sperm penetrates the egg, then life has begun.
Life begins at conception now, which would be conception. Okay, so that is what has been stated by the General Assembly. It was something that was passed in the mid-'80s, okay? And I think it was a response probably to Roe v. Wade. It was probably a response to a lot of other things that were going on. And so what the General Assembly did was, this is how we want you to construe the statutes. And it said, life begins at conception. It also said that life is accorded all the rights and immunities of a person, and that includes an embryo, okay? And then it goes on, to say that statutes must be construed in this light. You know, obviously we have abortion in Missouri. Obviously there's exceptions to that, but this is a new area, you know, and according to, in my mind, what the courts should do should look at what Missouri has out there and follow what the legislature has put out. And she just ignored it. The commissioner didn't even mention it. She just mentioned Iowa. She mentioned a few statutes in the family law area. You know, she mentioned a few statutes, but she didn't even follow Missouri law when it came to the statutes of family law. Because first of all, she said it was a property. She said these 2 embryos were property. Okay, that's clearly not the way that the legislature wants you to interpret things. But even let's say if it is, let's say for argument's sake that it is property, well then there's also a statute in the family law area that says that you, upon dissolution, you shall divide the property. It doesn't say you may.
Right, that's a directive.
That's a directive by the legislature. What she did was she said, oh, it's property, but we're not dividing it.
We're really almost out of time here. I was shocked when he gave me that time cue there.
Wow, I could talk a long time on this.
Yeah, I know you could, and I have so many more questions that I wanted to ask, but I have to ask a really very personal question. You don't have to answer this, but I would like to know
mind.
why these embryos, why not find a partner at this point in your life with somebody that is more compatible?
I'm glad you're asking that question. It's a very common question that I get, and I think a lot of people that aren't in my situation don't understand why. Why are you doing this? Why don't you just go find somebody else and do it? You know, do it again. Because they're my children, and because I view them as
embryos,
my children.
You're
yes,
saying.
Yes. I mean, it's just like if I were to get pregnant and if I lost my children at 2 or 3 weeks, I would still be grieving. You know, it wouldn't. One child does not replace another child, and that's the part I think that people have omitted from the conversation because they don't want to talk about it, you know, or it's not comfortable or whatever. But, you know, it's a good question that you're asking because it gives me the opportunity to tell people, this is my view. This is how I view those embryos, you know. And no matter what your view is, this is my view, you know. And in a society where we say that we try to understand other people's points of view, put yourself in my situation where if I were, you know, if these embryos were inside me, nobody would be questioning my
motherhood.
My motherhood and my drive or desire to carry them to term. But because they're in a petri dish, all of a sudden it's like, well,
in a freezer.
Yeah.
Not even in the petri dish.
They're in a freezer.
They're in a, you know, it's like frozen.
Yeah, it's like, you know,
meat.
out of sight, out of mind. But that's not, you know, I'm a mother. You know, I mean, I'm an attorney, and I look at this as analytically as I possibly can, but when it's all said and done, I'm a mother.
That's all the time we have. We'll have to have you come back as this progresses through the courts. Thank you very much for being with us.
Thank you, Lee. I appreciate it.
I've been speaking with Jasha McQueen. She's a mother that has 2 embryos frozen and would like to bring them to term. She and her ex-husband are in disagreement, and apparently so too are the courts. Stay tuned. This is going to be uploaded to YouTube, so go take a look at Conversation with Lee Presser. Thank you. See you next time.